My name is Vanessa Kogan. I'm the Executive Director of Stichting Justice Initiative, and I'm going to be discussing the ECHR's judgment in Volodina versus Russia, which is the first judgment to address domestic violence in Russia and discrimination against women. The applicant in this case was a victim of domestic violence that was throughout a 2-year period, which included beatings, including while the applicant was pregnant, which led to a miscarriage in one incident, death threats, stalking, kidnapping, and publication of the applicant's intimate photos online without her consent. During this time period, the applicant submitted over 8 complaints to the authorities and documented her injuries consistently. But there was no effort made on the part of the authorities to protect the applicant from further violence or to punish the perpetrator, who was known to the authorities at the time. The applicant tried to flee the abuse by leaving her hometown of Ulyanovsk and moving to Moscow, but the abuser was able to track her down by having planted a GPS tracker in her purse and then subsequently posing as a recruitment agent for a headhunting company and luring the applicant to a remote site from where he, with the help of an accomplice, kidnapped the applicant and forcibly took her back to Ulyanovsk. In the end, the applicant decided that she, in order to ensure her own safety, had to flee Russia and change her name, which she eventually did. The court found that the physical and psychological abuse that the applicant suffered amounted to inhuman and degrading treatment under the European Convention. And even more important are the court's conclusions under the procedural limb of Article 3, under which the court discussed the fact that there is no existing adequate legal framework to address domestic violence in Russia. And the main shortcomings that the court identified within the current framework are firstly that there's no definition of domestic violence as a separate offense. So it's not really conceptualized as a crime. There's a minimum threshold of gravity of injuries for launching a public prosecution in domestic violence cases, which is completely inadequate for addressing the problem of domestic violence, where it's really much more, the offenses are about a pattern and a dynamic of violence rather than particular separate specific incidents. It's really where the whole is greater than the sum of its parts. So the vast majority of domestic violence claims will not be sufficient currently under Russian legislation to launch a public prosecution. They may fall under what's known as the private prosecution jurisdiction, which is unfortunately excessively onerous for victims because it requires the victim essentially to act as her own lawyer and her own investigator, to question witnesses, to bring evidence before the court, and essentially to prosecute her own case. And if at some point, even at a very late stage of proceedings, the victim decides not to go through with the private prosecution, then all the charges will be dropped with no obligation to continue them on the investigative authorities. And finally, probably the most glaring shortcoming in Russian legislation currently is the absence of anything resembling a restraining or protection order, which for many years had created conditions under which women could not live free from the fear of being subjected to ill treatment, and under which they are not able to avail themselves of equal protection under the law, leading to gender inequality. If we turn to the status of implementation in this judgment 1 year since the judgment became final, on individual measures, unfortunately, nothing has been done to investigate the crimes against the applicant. And in 1 year's time since the judgment became final, the applicant has received 11 new refusals to institute criminal proceedings on her complaints from 3 different regional bodies. On general measures, one important and positive impact of this judgment on the national level was that it did force the government to come forward with a draft domestic violence bill just a few months after the judgment in November 2019, which was published for commentary. And this bill was essentially a redacted version of many different previous versions of draft domestic violence legislation that's been debated for decades in Russia. Unfortunately, while the government reacted swiftly, the current version of the proposed draft legislation would not protect victims. The terms are regressive, unclear, and certainly would not have protected the victim in the Volodina case and in most domestic violence cases. There's a clear consensus around this point within Russian civil society that the current version of the draft law would be ineffective. But the question remains of whether or not it would not necessarily, nevertheless, be a very important symbolic step. That would remain to be seen, but on a practical level, it certainly would not increase protection for victims. I'd like to dwell a little bit more on general measures and on where we think the committee's focus should be for defining the general measures that are needed to implement this judgment. So rather than focusing on the adoption of legislation per se, we believe that it's better to focus on remedying the specific shortcomings in current legislation that were indicated by the court in Volodina. And once again, those are the fact that there's no definition of domestic violence or its specific features and dynamics in current Russian legislation. There is currently no way to prosecute stalking or persecution or other forms of violence other than physical violence. And related to that, again, the most glaring shortcoming at the moment, the fact that there are no protection or restraining orders available under Russian legislation. Fourthly, the private prosecution jurisdiction, which is excessively onerous for victims and has a 90 to 95% dismissal rate. And lastly, the minimum threshold of gravity of physical injuries in order to launch a ex officio investigation, which is inadequate to ensure that domestic violence victims have access to justice. To give you an idea of where this issue is going in terms of the European Court and how it will come before the Committee of Ministers. As usual with Russia, it's the first case on a very important issue, but certainly not the last. This issue will remain before the committee likely for years to come. Already since the Volodina judgment, there have been 4 more judgments on domestic violence in Russia. There's likely a forthcoming pilot judgment on domestic violence in Russia that joins 4 applications, including an application by Margarita Grachova, who was a domestic violence victim who, when the authorities did not react with due diligence to her complaints about controlling behavior and physical violence, she had her hands chopped off by her husband at the time. The photo on the right gives an idea of what her life is like now. The court has begun to ask questions on the government's employment of a risk assessment strategy in domestic violence cases in its recent communications to the government. And lastly, in a recent case, the court registered an application without exhaustion of domestic remedies by the applicant. So this is a clear signal also that the court basically considers that there are no effective remedies at national level for domestic violence victims. In terms of recommendations on the Committee of Ministers monitoring, we think that the Volodina group should be examined under the enhanced procedure at least every 6 months. Individual measures should focus on effective ex officio criminal investigations, and general measures should focus not on the adoption of legislation per se, but on the elimination of current specific shortcomings that the court enumerated in Volodina. For further information, please visit a landing page that's devoted to the Volodina judgment that has more details on the applicant's story, the authority's response, the court's conclusion, some statistics on domestic violence in Russia, and reiteration of the steps we think are necessary to eliminate some of the glaring shortcomings that exist today. And there's also a Rule 9.2 submission by Stichting Justice Initiative that's available at the link below that discusses all of these issues in more detail. Thank you very much for your attention.